I'm Drew Stevenson, and this is a video for my professional responsibility class about conflicts of interest and getting informed consent from your clients to the conflicts of interest under Model Rule 1.7. Here we're really focusing on comments 18 and 19 to Rule 1.7, which sort of flesh out what do we mean by informed consent and how much information or subjective understanding or actual knowledge does the client have to have in order for it to count as them giving informed consent to the conflict of interest. Now, to just review, under Model Rule 1.7b, there's this provision that allows a lawyer to proceed with the representation in spite of a conflict of interest between clients, as long as you can satisfy these four conditions. So if there is a conflict, and even so, you reasonably believe that, as a lawyer, that you'll be able to provide competent and diligent representation to each affected client. In other words, you can be honest with yourself that you're not going to favor one client over the other. Then that's good, and then it can't be prohibited by law. I'll talk about that in another video. So there's no statute or case law in that jurisdiction prohibiting this type of representation when such a conflict exists. It doesn't involve the assertion of a claim by one client against another client in the same litigation or other proceeding before a tribunal. That's the sort of scenario you see in sitcoms where a lawyer is trying to be the plaintiff's lawyer and the defense lawyer in the same trial and running back and forth between tables. That's ridiculous, and we don't allow that even if both clients want it. And fourth, each affected client has to give informed consent confirmed in writing. And that's what we're really talking about here. So each affected client must be aware of the relevant circumstances and how the conflict could have adverse effects on their interests. So the information required, of course, is going to depend on the nature of the conflict and the nature of the risks involved. So to give an example, if you're representing people in a joint representation like co-plaintiffs or co-defendants, the issue with attorney-client privilege is going to matter in case they decide to sue each other later on in this matter. And the same would be true if you're representing multiple clients in a transactional matter, like forming a partnership or a corporation, or a buy-sell arrangement where one is selling commercial real estate or a business to another client. One of the implications of you trying to be the lawyer for both is that you're going to have privilege issues if they turn on each other later on and litigation results. Similarly, if you have known one client for a lot longer, you've done legal work or you're close personal friends outside of work with one of the clients and not the other, then you need to disclose that, because there's such a risk that either you'll favor one or that at least the one that you're closest to will expect you to look out for their interests more than the other person. And so each client has to be aware of the circumstances. If you're representing co-defendants in a criminal trial, you have to explain to them the risk that one of them could be offered a deal to testify against the other, a plea deal that even if they don't do that, when they get to trial, if one of them tries to downplay their involvement in the crime that they're being charged with, it basically shifts more of the blame by implication to the other co-defendant. So you have to explain that type of situation. If you're representing co-plaintiffs in a personal injury suit or a contracts dispute, you have to explain that that co-plaintiffs often disagree about whether to settle or go to trial, how much to settle for, how to divide settlements, whether they should contribute equally to the lawyer's fees out of their share, and so forth. So whatever the nature of the conflict is and how severe it is, how likely it is to create problems, you have to explain all of that to your client. If your client is not a lawyer, then you're going to have to explain it more than if they are lawyers, because then they might understand quickly what you're talking about. So for joint representation, multiple clients in a single matter, this could include possible effects on loyalty. As I said, often in joint representation, one of the clients is actually paying upfront for the lawyer, and the others are kind of along for the ride. Or you have a situation where one of the clients is someone the lawyer knows really well or is friends with, and some of the others in the joint clients in the joint representation are people the lawyer doesn't really know very well. And so there's a question of loyalty and whether you will favor someone or be expected to favor someone, confidentiality and attorney-client privilege, which I discuss in more detail in other videos, and then the advantages and risks involved. So there are, of course, advantages to joint representation. One lawyer is cheaper than two or cheaper than three. Sometimes the more lawyers you bring in, the more it just escalates the disputes and the contentiousness of the matter. It's also possible that the more people you bring in to a very sensitive legal matter, the more opportunities there are for sensitive information to be leaked or disclosed inadvertently or things like that. Obviously, there's just more, because there's more lawyers involved, there's more people that are going to come to learn of whatever the sensitive information is. And so sometimes there are advantages to having only one lawyer handling the situation for multiple clients. But there are disadvantages. As we've said, there's conflicts of loyalty. They could have different expectations. They could have testimony at trial that doesn't agree. They could have some sort of divergent interests, legal interests, or different ideas about whether to settle or go to trial, and so forth. So all of that has to be explained. Now, let's talk about the disclosures. Sometimes, actually, you're simply not going to be able to make the disclosure necessary to one client because the other client won't allow it. So let's say you represent different clients. There's one client, we'll call it Greenacre, that you've been representing for a long time on a number of sensitive matters. And you have a new client, Redacre, who has a legal dispute with Greenacre. And you think you could proceed with the representation. It's a simple matter and it's unlikely to go to litigation and so forth. Well, the problem is, let's say Greenacre doesn't want you to tell Redacre that you do legal work for them or the nature of the legal work. Well, in that case, you simply won't be able to get informed consent. You can't properly ask one client to consent to something if you have to give them vague information or not even tell them who the other client is that there's a conflict with that they're consenting to. So if they're giving informed consent, that will necessarily involve disclosing the identity of the other affected clients and probably the nature of the conflict. Like, do you represent them on another matter? What other type of matter is it? Are you concerned that they're going to be a witness for the other opposing party in the litigation? Whatever the nature of the conflict is, if you're going to get consent, you really have to explain it, and you have to explain who the conflict is with. And if you can't, that's a deal breaker. You can't get informed consent under those circumstances. And that concludes our little lecture about informed consent to conflicts of interest under ABA Model Rule 1.7.